This is Professor Susan Gillis, and this is a makeup from Friday's class, which was cancelled due to snow. To successfully complete this class, you need to print out a copy of the questions that we're going to be going over. You can find those questions on course materials, and you can either print out a copy of this PowerPoint, which has the questions in, or you can print out a copy of the Socratic questions, because those are the questions we're reviewing. So you only need one of these two, but you need to have it out and be looking at it to successfully complete this class. So take a moment, pause the video, and find these questions. Okay, so the topic we are looking at is when a complaint fails to comply with Rule 8A. And there are three requirements in 8A. A complaint has to have a statement of jurisdiction. It has to state the claim or state the cause or causes of action the pleader is seeking relief for, and then it has to have a demand for relief. And we're focusing on 8A2. And we're looking to see when a pleader fails to state a claim. In other words, fails to meet the requirements of Rule 8A2. And as you saw in the material, there are three ways, easy ways, where it's easy to spot that the claim is not properly stated. The claim is not recognized by law. The pleader gives us facts that show they can't recover, they plead themselves out of court, or they're completely missing an element. Let's look at these three easy ones, and then we'll come back and look at the tough one, plausibility. If any failure to state a claim is present, what you're likely to see is that the defendant will file a motion to dismiss, and the defendant will ask the court to throw out the complaint because it doesn't comply with Rule 8A. It doesn't state a claim. The court may grant the motion, throw out the complaint, but sometimes the court will give the pleader leave to amend, meaning that they can go back and try and fix the problem if possible. So let's look at the first three easy ways to spot a failure to state a claim. So for each of these questions, you're going to assess whether one of these is present, or if not, if the pleading does state a claim, does meet 8A2. Find question 1 and read over it. Notice that for all the complaints we're looking at, we're going to presume they comply with Rule 10 and have a caption. We're also going to presume that they have a proper jurisdictional statement and a proper demand for relief. So what you're going to focus on for each of them is whether the text I give you, right, the text in the complaint, meets the requirement that it states a claim. So go ahead and try to answer question number 1, and then I'll review it with you. Okay, you should have concluded that this complaint fails to state a claim because the claim is not recognized by law. It's legally insufficient. Why? Even if you don't remember all of tort law, you should at least remember that there's no cause of action for not lending someone a phone. It simply is not recognized by law. Let's do another easy question. Number 2. Once again, read through this complaint and what I tell you about the law and select an answer. Pause the video while you answer. Good, you should have selected B. This complaint fails to state a claim because the facts show that the plaintiff has no possible claim. The plaintiff has pled herself out of court. Why? She has pled that she was fired, and at that time she was 38 years old. However, you're told that the statute only grants a cause of action if the employee is 40 years or over. Therefore, she set out facts showing it's impossible for her to recover. She's pled herself out of court. If you selected A, this is not as good an answer. Notice it's not that the law does not recognize a claim for age discrimination. The law does. So A is incorrect. Rather, the problem is that the plaintiff has pled facts showing she can't recover under that recognized cause of action. Let's try another one. This time she's amended the complaint, and now you have to again assess whether she stated a claim. Once again, pause the video, answer the question, and I'll review it. You should have concluded that here she has stated a claim for relief. She's truthfully amended to say she's 57 years old, and therefore she's stated a claim because I tell you that she's alleged all the elements. Does it matter that she has never mentioned the act in her complaint? And the answer is no. So if you selected A, it's incorrect. You do not need to state the legal authority or legal theory under which you're suing as long as you allege all the elements. The Supreme Court held this in the Shelby case. So you could technically sue for battery and never say the word battery. This is not good lawyering, and even the Supreme Court in Shelby suggested the parties should state what statute they were suing under. So whenever you plead, please do include the statute that creates the cause of action, or say battery or negligence or breach of contract, but technically you don't fail to state a claim if you omit it. You just look like a bad lawyer. Now try number 5. Once again, pause this video, read through, and select an answer. You should have realized that here the complaint failed to state a claim because an element is entirely missing. What element is missing? Let's look at the text of the complaint and the elements and see if each is pled. The first element we're looking for is that the defendant acts. Here the complaint said that defendant John Doe's 1 and 2 touched Murray. Touching is an allegation that the defendants acted, so therefore that element is properly pled. If we look at element number 3, defendant's act results in contact with the plaintiff. Here again the complaint alleged that defendant's touching caused injury to his back and wrists. So we see they've alleged a harmful, injurious touching. How about element number 2? There is no facts, no words in the complaint that allege that the defendant had intent. Therefore, this plaintiff has completely omitted any allegation of number 2. They simply skipped over that element. Therefore, it fails to state a claim. Now we're going to turn our attention to the toughest way a complaint can fail to state a claim, the plausibility test, introduced by the Supreme Court in Twombly and refined in Iqbal. As set out in the materials you read, you have to take 2 steps to apply this test. The first step is to ask whether words set out in the complaint are facts, who, what, where, when. In other words, they're concrete, specific allegations versus general conclusions. General conclusions simply repeat the elements. They're a bare repetition of the words in the element without any concrete information. Once we've segregated facts from conclusions, then we ask whether the facts, looking only at the facts, presuming them to be true, whether they are enough to say the claim is plausible. There's a reasonable inference that the claimant will recover. So the second step is to ask, are there enough facts to state a claim? The more gaps you see, the more you don't know who, what, where, when, the more likely it is that the complaint will fail to state a claim because it fails the plausibility test. Remember, the term plausible or plausibility is a tough concept to understand. One way to understand it is to contrast it with 2 other possible tests of the amount of facts in a complaint. The prior standard used to ask if the plaintiff could possibly succeed. In other words, the court would look at the statement of the claim and ask if it showed the pleader could possibly recover after they had an opportunity to do discovery and find out more facts. The plausibility standard demands more facts than that. The court has to conclude that when it looks at the facts in the complaint, the pleader has shown they are plausibly entitled to relief. There's a reasonable inference that they can recover given the facts set out or alleged in the complaint. However, notice that at this stage we're not asking if the pleader will probably recover. That's the standard for trial. Finally, notice that the test is not generally whether the judge believes the facts or not. We have to presume that any concrete factual statements are true. Why? We're only at the pleading stage, the beginning of the case. We have to presume everything in the complaint that's a fact is true, and then ask if these facts are true, can the pleader recover? Only at trial will the jury get to decide if they believe or don't believe the facts alleged. Now we're going to try and apply the test. This is a tough test to apply. It's not enough that you've memorized the 2 steps. You have to repeatedly apply it to make sure you understand what this test is asking. We're going today to look at some Socratic questions, and then on Friday, next Friday, we'll look at a Sixth Circuit case to make sure you understand what this test means. Let's do some easy introductory questions. Question 5. When would you be required to do an in-depth analysis of the plausibility test? Pause the video, answer the question, and I'll review. You should have selected D. The plausibility test must be applied in an in-depth manner when you think that the complaint does not have any facts about one or more elements and instead tries to use conclusions to support its allegation. In contrast, in A, if the complaint has specific concrete facts for each element, then you know it easily meets the plausibility test and an in-depth analysis would not be required. Now let's think about the plausibility test. What best describes the 2 judgment calls the plausibility test requires you and the trial court to make? This is a multiple select, pause, and then click when you've answered. The 2 steps, the 2 judgment calls you have to learn to make are to work out what allegations in the complaint are conclusions, bare repetitions of the elements versus facts, and then secondly, whether there are enough facts to show the plaintiff will plausibly recover. Choice B is wrong because the standard is wrong. The test is not whether the plaintiff will possibly recover, rather it's a higher standard whether there are enough facts to show the plaintiff will plausibly recover. C is incorrect because remember we're not asking if the judge believes these facts. Rather, unless the facts are truly bizarre, something we'll return to the end, the judge must accept any concrete facts as true. Now we're going to work through applying step 1 and then step 2, and we're going to do so with a complaint where Miss Parsons is trying to sue for battery. So here's count 1 of her complaint, her battery, right? And what I ask you to do is to pull it apart and select from below which of these you think count as a concrete factual allegation that has to be presumed true, and then not select anything that's simply a repetition of an element, a bare assertion or legal conclusion. Pause the video and do that. Here's what you should have concluded. The first 3 are easily concrete facts. What about D? Acted with intent to make harmful contact. If you contrast D with the legal element, you'll notice that D simply repeats or reasserts a legal conclusion, intent to make a harmful contact. The pleader is simply repeating the law, not giving concrete specific facts about how this occurred. Same with F. as a result of his act, plaintiff Parson suffered a harmful contact is simply a reassertion or repetition of the legal element number 3, the defendant's action resulted in a harmful contact. What's key to realize is we're not saying it's wrong to include these in the complaint. All we're saying is that without some concrete facts to back these up, you cannot use these to successfully state a claim because there's not enough factual content to back up that element. We now know how to apply step 1. For the same complaint, now look at question 8 and try and apply step 2. Now you have to ask yourself if there are enough facts in the complaint we just looked at to state a claim under the plausibility test. Take a moment, think this through. It is a tough test to apply. Okay, you should have selected answer C, that this fails the plausibility test. Why? All of the answers look good because all of them focus on whether there are enough facts, right? And that's what the plausibility test is about. Are there enough facts to show that the plaintiff is plausibly entitled to relief? You should actually have easily eliminated A and B because they give the test incorrectly. If you look at A, it asks, is plaintiff possibly entitled to relief? And B asks whether it gives the defendant notice. It's no longer sufficient under the plausibility test that the defendant gets notice. There also has to be a reasonable inference that the plaintiff will recover. That leaves us with C and D. Let's knock out D. What's wrong with D? Notice D says it fails to state enough a claim because there are not enough facts to prove that it is true that defendant intentionally harmed the plaintiff. That's not the plausibility test. Remember, we're only at the pleading stage. The plaintiff does not have to prove these facts are true. We simply ask if, given the facts alleged, presuming that they are true, the plaintiff has a plausibly stated a claim. So we're not requiring proof at this stage, we're just asking whether concrete facts have been alleged. So that leaves us with C, which is correct. Here the pleader has failed to state a claim because they simply have general statements about intent and contact and no facts about those elements. Let's go back and look at the complaint and make sure we realize why that is true. Look at it again. There are lots of facts about how Dekler acted, right? For instance, it tells you he acted with the intent to make a harmful contact, and as a result, she suffered a harmful contact, suffering a broken arm. We don't know. We do know where, New York, when, 2014, who, Dekler, but we don't know anything about what he did or how he even made contact. Was he throwing a frisbee? Did he open a door without looking? There's no concrete facts to either back up the fact that he acted with an intent or to even back up what the contact was. The plaintiff instead has simply taken the legal requirements and reasserted them. And this is a classic illustration of how you fail the plausibility test. So the correct answer to number 8 is it fails because there are general statements about intent and contact, and when we ignore those conclusions, we don't have any concrete facts from which we can reasonably infer the plaintiff is entitled to recover for battery. This time, we're going to look at a revised complaint, which again tries to assert a claim of battery by plaintiff Parson. So we fixed up the complaint. So now your job is to once again work out what you think are factual allegations, right? Concrete specific facts alleged in this complaint, which we must accept as true. Pause the video and make your selection. Okay, so hopefully you picked A, B, C, D. Declan was driving down West 65th. He deliberately swerved, steering his truck into Miss Parsons. You might have been worried about the fact deliberately swerved. It's true, plaintiff may have a hard time proving this, but notice it's okay for her to allege that he swerved, steered his truck into her, and that he did so deliberately. We've got these facts that will help us prove to the jury that it was deliberate. So this is a factual assertion. Simply because it's about someone's state of mind does not make it not a factual assertion, as long as it has other facts to help you. We also should have selected as a fact that plaintiff Parson was involved and that Declan collided head-on with Parson, right? And she suffered severe injuries. Now let's apply the second step of the test to this revised complaint. Does this new complaint state a claim under the plausibility test? And the answer you should select is A. You should realize, going back, that we now have concrete facts about every element. So let's look for every element. Did he act? Yes, he was driving his truck. He swerved. How about intent? Notice we have a conclusory statement, intend to make harmful contact, right? But now we have concrete facts about that too, that he deliberately swerved, steering his truck into her. Those concrete facts are enough to allege the element of intent. Finally, we need to show a harmful contact. And now we have information, concrete facts that back up the assertion of a harmful contact. He collided head-on with Parsons, causing her to suffer severe injuries, including a broken arm. We know there was contact. He collided head-on with her. So do you see that we went from having mere assertions of each of these elements to the assertions still properly in the complaint, but backed up with concrete facts, which, if true, are going to allow her to recover. So yes, this will pass the plausibility test. We've plugged the gaps we saw in the original complaint. Let's do a final review and then another set of hypos. So remember, what is it that the plausibility test is asking you to decide? Look at the answers, select one, and then click to continue. The plausibility test does not ask, A is incorrect, because it does not ask if you've given all the details. You only have to give details needed to state a claim. B is incorrect because the plaintiff does not need to show she'll probably recover at trial. Rather, the question is correctly stated. And C, has the claimant got enough facts to show she will plausibly recover? In other words, when the plaintiff presumes the facts are true, the court can reasonably infer the defendant's going to be liable. D is incorrect because the test is not possibly, right? This is the old notice standard, which was rejected by the Supreme Court. This test is tough to master. So the way to do it is to do it again and again through different claims. So let's try one more example, question 12, which is a claim for negligence. Here's what the plaintiff puts in her first complaint, so read it over with care. And presume that the elements of negligence are duty breach, in other words, there was negligent conduct, causation, and injury. And the question you have to answer is, which of these elements do you think the trial court might hold failed the plausibility test? In other words, which of these elements Does this seem to be simply a bare assertion of and not concrete facts backing up? Take a moment and answer the question. You should have picked out duty breach. Let's do the easiest one, injury to plaintiff. If you look at paragraph 2 and 3, 2 says that plaintiff suffered bodily injuries, and then 3 gives us lots of facts, a broken arm, a concussion, hospitalization. So there's lots of concrete facts which, presumed true, are going to show injury to the plaintiff. What about causation? In paragraph 2, the plaintiff alleges that defendant's negligent conduct caused her to suffer injury. This statement that their breach caused injury is enough to concretely allege causation. You might think it's a little short, but then ask yourself, how else could you allege that something caused something? You just have to say the storm caused the class to be cancelled, right? So this conduct cause injury is enough for causation. Why do we say that duty and breach, the allegation of negligent conduct, is problematic? Take a look at the complaint again. Suppose you were the defendant declar. What is Ms. Parsons saying you did? All it says is that you negligently injured her. Were you driving a car? Were you flying a plane and crashed into her? Did you open the door, hitting her? Did you throw a spear across the road? There's absolutely nothing here to tell you what conduct by you was allegedly negligent. Therefore, negligence is just a conclusory assertion. All the complaint says that the defendant negligently injured her is negligent conduct, right? Do you see how that's a bare assertion of the element, a conclusion, with no conduct specified to back it up? So we're worried about whether the duty and breach element can be met or is simply going to fail the plausibility test. Let's see if you could work out how to fix it. In other words, if you were looking at the same complaint, which of the facts, if added to the complaint, would solve the plausibility problem? Take a moment and select your answer or answers. It's a multiple select. You should have selected B and F. Now notice, all these are concrete facts, and you could add any or all of them to your complaint. But remember, our plausibility problem was whether defendant acted negligently, right? It just says negligent conduct. So we want to add facts that specify what that negligent conduct was. Because if we add B and F, now declar knows exactly what negligent conduct we're alleging. He swerved across 2 lanes, he was on the phone. So if these concrete allegations were added to the complaint, it would solve the plausibility problem. So notice the plausibility issue is not just you add a whole lot of facts. The key is whether you have facts that back up each element. When the court looks at the complaint, it can find concrete facts which, when presumed as true, give a reasonable inference that plaintiff can recover. Let's try one more complaint. This one's tough, so take your time and think about the plausibility test. Look at the words in the complaint really carefully and ask yourself if you think the plausibility test is met. So you're selecting true or false. This complaint meets the plausibility test and so states a claim for relief. I think the better answer here is that it's true. It does meet the plausibility test. Let's think about it. What element are we worried about? It's a negligence claim. We're not worried about causation. We're not worried about injury. We're worried about whether there's enough detail about the alleged duty breach. What detail do we have? Notice when we contrast to the complaint that we looked at a few minutes ago that failed it, here the complaint does not simply allege that the defendant acted negligently, right? We know that's a legal assertion. Instead, it alleges that he was driving. He drove negligently and struck her, and that it was his driving that the plaintiff is complaining about. It's a concrete fact, right? An allegation of a concrete fact that he was driving and hit her. Now, I absolutely agree with you that we would like more information. How was he driving negligently? Was he speeding? Was he drunk? Did he swerve? However, all we're asking is whether he can plausibly state a claim, right? Is there a reasonable inference that Ms. Parson can recover? And most courts would hold that if you simply allege negligent driving, hitting the plaintiff, telling you exactly where and when she was struck and her injuries, that's going to be enough. It's on the line, but it's likely enough to meet the plausibility test. The court has said that we should apply the test using common sense, and common sense tells us that people get hit with cars when there's negligent driving. And so there's a reasonable inference that plaintiff's going to be able to prove that when defendant Dekla drove into her on this date in this city when she was rollerblading along the street, there was negligence. So here, plausibility is met. I want to look at one final, a little questionable hypo. So read through this hypo. I know it's hilarious. Okay, so this illustrates a rare occurrence where sometimes by plausibility we mean that we're going to disbelieve facts, right? Most of the time, plausibility requires us to believe concrete facts, right? However, even Justice Souter and Justice Kennedy, the two main advocates for this test, said that at a certain point the facts are so crazy that we can disbelieve them. So when you read this through, it does have lots of concrete facts, right? The problem is we just think they're too far-fetched. So at a certain point, you can add into the plausibility test the idea that the facts are just way too crazy, and that's why it fails. Notice that what the court has suggested is way too crazy. In other words, where the court is allowed to say, no, you're not going to get credit for that fact, even though it's concrete. The illustrations the court has given is actually the fact that there are aliens from Mars living among us, or that time travel is possible, or that you met a little green man. So it's really got to be extreme before plausibility allows you to disbelieve a fact. But it is possible, so this is a little twist on the end of the test. So what are we doing next week? Remember, Wednesday after Crim Pro, you have an opportunity. We're going to look at questions about the draft complaint, and we're going to review a Sixth Circuit case. I'll see you in class on Friday.